Good afternoon, and thank you all for joining us today. I'm Flavia Seval, Chief Executive Officer at the Jerusalem Institute of Justice. Before we begin our lecture today regarding the relationship between international humanitarian law and international human rights law, I want to tell you shortly about the Jerusalem Institute of Justice. JIJ is a leading legal research institute that strives to uphold human rights in the Middle East and safeguard the legitimate standing of the State of Israel among the nations. Our international law and public diplomacy department operate both in the international legal and public diplomacy arenas. JIJ is proud to hold the most prestigious consultative status to the Economic and Social Council of the United Nations for our contribution to the protection of human rights. The legitimacy of the State of Israel is under constant attack. In recent years, Israel has been forced, time after time, to thwart Hamas's terrorist aggression in order to protect its citizens. Israel must launch military operations to inflict damage on the terrorist infrastructure built by Hamas in the Gaza Strip. During and after every military operation, Israel is accused of violating international humanitarian law. Every lawful defensive action on part of Israel is met with strong pro-Palestinian, anti-Israel propaganda. Allegations about Israel's violations of humanitarian law create tremendous damage to Israel's image and are slowly eroding its legitimacy. Claims regarding Israeli violation of international humanitarian law and human rights law are refutable. They are unfounded and stand in stark contrast to the laws, the morality of the State of Israel, and the harsh code of conduct that characterizes the IDF in its military operations. In today's session, I want us to dive into the fascinating world of international law. We will take you through the developments, principles, and key institutions in international humanitarian and international human rights law. And we will see how Israel and Hamas comply or do not comply with the law of armed conflict. With me today is Advocate Uri Morad, Director of JJ's International Law and Public Diplomacy Department. Welcome, Uri.
Thank you, Flavia. Thank you for having me here today. Flavia, I believe that in light of the challenges facing Israel today, we must be informed so we all be able to stand up against the lies spreading around the globe that try to both demonize and delegitimize the State of Israel.
I agree. And can you define for us what is international humanitarian law and what is international human rights law?
Of course. So let's start with international humanitarian law. International humanitarian law, otherwise known as the laws of armed conflict, seeks to limit the means and the methods of warfare in order to protect persons who are not participating in the hostilities. In other words, international humanitarian law is in place in order to regulate the conduct of war.
And how did international humanitarian law evolve in time?
So it actually goes back at least to the 19th century when Henry Dunant founded the Red Cross to ensure protection and assistance for the victims of armed conflict. Two large codifications of international humanitarian law took place during the 20th century, and that was the Hague Convention of 1907 that deals mostly, I would say, with how warfare is conducted, and the 1949 Geneva Conventions that deals with the protection of civilians and combatants no longer taking part in the hostilities, including the wounded and the sick. And these two conventions, the Hague of 1907 and 1949 Geneva Conventions, are complementary conventions.
Then what are the fundamental principles of international humanitarian law?
So international humanitarian law includes basically three key principles, starting with the principle of distinction that requires that the parties to an armed conflict will distinguish at all times between military objectives and civilian objects. This means that civilians and military personnel must be both identified and treated separately. Article 1 of the Hague Rules sets out 4 requirements to make those competents identifiable. Firstly, command by a person responsible for his subordinates. Secondly, bearing a fixed and distinctive sign. Thirdly, carrying weapons openly. And lastly, conducting their operations in accordance with the laws of our conflict and the customs of war. In addition to the distinction between competence and non-competence, civilian and military objects must also be distinguished. Operations are to only be directed against military targets. Indiscriminate methods of warfare which are not capable of separating civilians and military targets are therefore prohibited. By the way, this does not mean that there cannot be damage to civilian property, but such damage is only legal if it is a side effect of hitting a legitimate military target. Moving on to the second principle of international humanitarian law, and that is the principle of proportionality. The principle of proportionality requires that the effects of the methods of warfare used in an armed conflict must not be too extreme in relation to the military advantage sought. Thus does not imply that there be no harm to civilians. Again, it only requires that it is not excessive. For example, it means that if a terrorist sniper who is shooting at soldiers or civilians, firing and shooting at him is definitely proportionate, even if as a result an innocent civilian neighbor is harmed. And the third and last principle that construct the key principle of international humanitarian law is the principle of precautions. The principle of precautions determines that all feasible precautions must be taken in order to avoid and minimize incidental loss of civilian life, injury to civilians, and damage to civilian objects.
Then who is responsible for enforcing this international humanitarian law?
So since the 1990s, international criminal tribunals were created in order to prosecute individuals for those international crimes. The International Criminal Tribunal for the former Yugoslavia and for the one for Rwanda are both good examples of that. Today, the most important one is the International Criminal Court in The Hague, which was established back in 1998 by the Rome Statute.
So bringing it back to our part of the pond, to the Middle East, how do Hamas and Israel approach international humanitarian law, and how do they adhere to the principles you just mentioned?
Great question. So Israel respects its obligation according to international law, and yet a distorted interpretation of international humanitarian law is actually frequently used. We see it a lot. They use it as a tool to bash Israel. And if we took a closer look at the most recent conflict between Israel and Hamas, we can see beautifully how this twisting of international humanitarian law creates a fertile ground for a propaganda attack against Israel. And this propaganda attack leads to a significant damage to Israel's image in both the public diplomacy and the legal spheres. Let's examine through the prism of the binding norms of international humanitarian law the acts of both sides, Hamas and Israel, during the 11 days of fighting named Operation Guardian of the Walls, which took place just last year during May 2021. Firstly, I want to take a closer look at the principle of distinction. Again, the principle of distinction requires that all sides to a conflict, in this case both Hamas and Israel, would make a clear distinction between military forces and civilians, so that each side would be able to aim at legitimate targets only. Civilian targets can be legitimate if by their very nature, location, purpose or use they make an effective contribution to a military operation. Moving on to Hamas. Hamas's indiscriminate firing of rockets with a clear intent of targeting uninvolved civilians is both indisputable and constitutes a breach of the principle of distinction under humanitarian law. However, that does not mean that Israel is released from fulfilling its own obligations under international humanitarian law.
So besides firing rockets without distinction into Israel, we also know that Hamas is firing indiscriminately at Israel from residential areas in the Gaza Strip.
True, Hamas and by the way also the Islamic Jihad. They're not only firing from schools and kindergartens and hospitals and mosques, but their entire military operations are located within civil infrastructures. And we need to remember, mixing military and civilians together makes Israel's attack align with the principle of distinction, even if civilian casualties are involved.
And yet, those who are critical of Israel would argue that the number of civilian casualties and the destruction in the Gaza Strip indicate that Israel used excessive force.
And that actually leads us to the discussion around the principle of proportionality. Flavia, we need to understand, conducting a war without having civilian casualties or damage to civilian infrastructure is unrealistic, as clearly expressed in the founding document of the law of war, the Geneva Conventions. The rule is that civilian casualties must be proportionate to the military objectives. The principle of proportionality does not establish an exact formula to determine whether an act constitutes a proportionate or not proportionate civilian damage. In our case, civilian casualties and damage to civilian infrastructure is, unfortunate as it may be, is a direct result of Hamas's abuse of the Palestinian civilian population in the Gaza Strip that uses them frequently as human shields. In addition, Israel's attack clearly meets the requirement under the principle of proportionality, as Israel uses today the most sophisticated technology that allows Israel to use minimum explosives and hit its targets with minimal collateral damage. Now, let's take a look about the numbers for a moment. Operation Guardian of the Walls, in which Israel basically acted to, I would say, destroy Hamas's terror tunnels project in the Gaza Strip, claimed the lives of approximately 200 terrorists. 20 of them, by the way, are considered senior Hamas figures. And apart from these Hamas figures, the operation also claimed the lives of about 225 unarmed civilians. This number reflects the total number of victims, including those who died as a direct result of Hamas's shooting. The rest died as a result of placing innocent Gazan civilians, including children, in highly dangerous places in proximity to rocket launchers. These are relatively low numbers. We need to understand that 225 is considered a low number of casualties, definitely in light of the struck over the 1,500 terror targets by the IDF.
Uri, and how about the principle of precautions? The third principle we mentioned, how does this apply?
So on Hamas's side, Hamas, as usual, didn't give any warnings or take any measures to minimize the damage of civilian targets before he fired over 4,400 rockets over Israel. Approximately, by the way, 680 of those basically misfired and fell within the Gaza Strip, causing Palestinian casualties. Hamas's stated agenda, we need to understand that, Flavia, that the whole agenda and the whole operation of Hamas is based on causing harm to civilians. On the Israeli side, the intent is the opposite. Israel is going above and beyond, I would say, what the law requires. Israel allocates significant resources for that purpose. The IDF uses all available methods to minimize civilian casualties, including giving warnings, phone calls, and time to evacuate sites before taking action. That is why a significant number of casualties are Hamas combatants, and that is exactly why about 115 of those 225 dead in Gaza belong to the terrorist organization in Gaza, including about 65 of them directly from Hamas.
So Israel actually meets its obligation under the principle of precautions.
Definitely. But not only in order to meet its obligations under international humanitarian law. Because the values of morality and the importance of human life are engraved in Israel and they are engraved in the IDF.
But unfortunately, this is not reflected in the actions the United Nations has taken against Israel following Operation Guardians of the Wall.
Of course not, and to tell you the truth, Flavia, I would be very surprised if it was. It's not that the UN is unaware of how each side conducted itself. The law, as we've seen before, is pretty clear. But when political agenda and bias controls every single step that the UN takes, Israel finds itself filing new accusations. This time, after Operation Guardian of the Walls, the UN Human Rights Council formed an unprecedented commission of inquiry that is examining alleged crimes committed by Israel during the conflict.
So what can we do to prevent that from happening again?
Unfortunately, Flavia, I don't see it happening. We cannot prevent it, What we can do or should do is promote steps to minimize and control the damage. More specifically, Israel needs to uncompromisingly adhere to the rules of international humanitarian law at all times. We must also need to improve our public diplomacy efforts. Israel must have a functioning body that would be able to immediately disprove the many lies spread in the media. And Israel should also continue to encourage internal proceedings and self-investigations in order to look at every alleged misconduct by the IDF. By doing so, Israel is respecting another principle of international humanitarian law, and that is the principle of complementarity, which removes the jurisdiction of the International Criminal Court to interfere.
Israel's approach to international humanitarian law stands in stark contrast to her enemies, who violate the law by strategically operating from civilian infrastructure, by carrying out indiscriminate attacks against Israeli civilians. And now I want us to move on to the discussion regarding international human rights law. Let's start by explaining what it is.
So, international human rights law is a set of international rules set out in a treaty or custom, which states are bound to respect. These human rights standards are characterized as the duty to respect, the duty to protect, and the duty to fulfill human rights. International human rights law has a great deal of application to everyday life. It ranges from employment protection to privacy protection, from protecting the vulnerable to freedom of religion and access to medical treatment.
What are the origins of international human rights law?
So, contemporary human rights law starts with the UN Charter, an international treaty signed back in 1945. The United Nations Charter then established the UN Economic and Social Council, also known as ECOSOC, whose mandate involves making recommendations for the promotion and protection of human rights. ECOSOC immediately set up the Commission on Human Rights, which was responsible for drafting the Universal Declaration of Human Rights. This Universal Declaration of Human Rights was proclaimed in December 1948 as a resolution of the General Assembly of the United Nations. This declaration is not by nature legally binding, but it sets important goals to be achieved.
We know through the work of JJ during the years that other regional human rights treaties and treaty bodies started to emerge and form a major source of international human rights law, such as the International Convention on Civil and Political Rights, the Convention on Economic and Social and Cultural Rights, but more specifically, there is other treaties that were created, like the Elimination of Discrimination Against Women or the Convention on the Rights of a Child. That is just to name a few. But what are the states' obligations with regards to these treaties?
So the rights outlined in the treaties you've just mentioned, Flavia, create obligations of conduct and outcome on the states who are party to these treaties. These obligations can be broken down into three sublayers, as we've mentioned before: to respect, to protect, and to fulfill. The obligation to respect requires states to refrain from interfering with rights, while the obligation to protect requires the states to protect individuals from having their rights infringed by third parties, and the obligation to fulfill requires the states to take positive actions in order to bring about the realization of these rights. The key principle of international human rights law is that only states are legally bound by these obligations, since they are the party to these treaties.
So I understand that individuals are not legally bound by these obligations.
No, but they become third-party beneficiaries. Maybe in other words, by default, international human rights law is vertical, but it's not horizontal. The duty is on the state, so that individual can enforce their rights upwards against the state institutions, but there are no duties across private companies and individuals. If a private company or another person threatens an individual's right, the duty remains on the state to protect that individual from that other party. When states fail to do that, that individual can sometimes take their country to court to get his remedy. Alternatively, for individuals to enforce human rights horizontally against each other within the domestic legal system, the relevant treaties must be transposed into domestic law and are subject to the jurisdiction of a local court. In times of emergency, certain human rights treaties allow states parties to exempt from their obligations. This is called derogation in legal terms. It means they can pause the application of that right for a limited time. The validity of the derogation is often determined by the severity of the situation itself. However, some fundamental rights, such as the right to life or the right for freedom or freedom of torture and slavery, are non-derogable. This creates a tension between human rights law and international humanitarian law, as we will see later.
Is it possible that a state party would not accept a certain element of a treaty?
It is possible. States can sometimes have reservations regarding certain elements of human rights treaties. These reservations means that those states do not agree with or will not adopt those rights.
So, what is the difference between reservation and derogation?
So, a reservation occurs before the ratification of a treaty, and it means that certain human rights expressed in the convention will not ever be binding on that state, whereas the derogation is a temporary suspension of a right due to a particular emergency.
What are the instruments then available for making sure states actually comply with the rules set in international human rights law?
So broadly speaking, there are three types of bodies, starting with the UN Charter-based bodies, following by the treaty-based committees, and with regional conventions.
And we can agree that in each one of them has a different area of responsibility and a reporting mechanism.
Exactly.
And what about human rights in Israel?
So Israel is actually a party to several international human rights treaties, and it protects human rights in its domestic legal system through its basic laws. Israel's Declaration of Independence promises that the State of Israel will maintain complete social and political equality for all its citizens without distinction on the grounds of religion, race, or sex.
And does Israel truly provide equality for all its citizens?
So, first and foremost, Israel is not a perfect country, and it does make mistakes like any other country in the world. What I can surely say is that Israel is an island of sanity, I would say, in the Middle East or in the whole region. Israel is actually a beacon to the nations in the way it applies international human rights obligations. With an internationally highly respected judicial system, Israel has shown time and time again through the years that it is both capable and willing to conduct its own investigations whenever it sees the potential infringement of rights, also during times of war. Israel promises and protects the delivery of equal rights to all of its citizens.
Uri, can you describe now for us the relationship and maybe the differences between international humanitarian law and international human rights law?
Yes, so in many respects, international humanitarian law is complementary to international human rights law, as it actually represents the minimum human rights standards in times of war. With that, I would say that there are a few basic differences between these two legal systems. Firstly, international human rights law only creates rules for states. In contrast, international humanitarian law creates rules for both states and non-state actors, such as unofficial armed groups. Secondly, international human rights law is supervised by the bodies established under the United Nations Charter or other human rights treaties. In contrast, the International Red Cross, whose job is to ensure protection and assistance to victims of war, supervise international humanitarian law. Thirdly, in principle, international human rights law applies at all times, while international humanitarian law is only applicable during times of armed conflict. Although there is a debate regarding the extent to which human rights law applies during armed conflict as well. And lastly, the protection offered by international human rights law is deeper than international humanitarian law. However, in many respects, the scope of international humanitarian law is a bit broader because it is not limited to protecting persons, but also extends to civilian objects, cultural property, and many more.
And what happens if these two provisions, these two laws, contradict?
So that is an interesting issue, I have to say. Here's a clear example. The right to life, which is contained in many human rights conventions, has no permissible exceptions. In international humanitarian law, there is an exception to the right to life, such as when a combatant lawfully takes the life of another combatant, or even when a civilian is accidentally killed in the process.
And how can these two views on the legality of taking life be reconciled?
So the International Court of Justice issued an important judgment back in 1996, observing that the protection of the International Convention on Civil and Political Rights does not cease in times of war. The court said respect for the right to life was also not subject to exceptions like other rights.
So, if there is no exception to the right to life, how can warfare still be legal?
So to put it simply, although the right to life still applies, during a conflict you need to utilize the standards of international humanitarian law rather than those offered by the human rights law, in determining whether the right has been violated, of course. This rule applies to another tensions between those two legal systems. For example, while the detention of civilians or prisoners of war is technically contrary to the principle of liberty in international human rights law, it is permissible under the special standards of international humanitarian law that applies again during an armed conflict. With that, I would add that the tensions and debate still exists. For example, in the kill or capture debate over whether states, when possible, should capture combatants instead of killing them in order to uphold the human rights.
I personally believe the application of the law, humanitarian law or human rights law, is it's kind of amazing and really impacts our lives. We have learned so much today. We have outlined the basic principles of international and humanitarian law and explained how it works to prevent and minimize harm to civilians and their properties. We then saw how Israel adheres to these rules during the engagement of war and how Hamas does not. And we have seen the historical development and content of human rights and humanitarian law and understand that it's complicated yet possible to operate in both systems legally and with high moral standard. I thank you so much, Uri, for this fascinating session.
Thank you, Flavia. Thank you for having me here today. And see you all in our next webinars.